Hello students. Uh, Actually we have been discussing about various parts of the industrial microbiology with the downstreaming process we have been dealt with. Okay, and today let's go for the topic on something where we learn like how to protect our patents or some cultures or poetry or literature, etc. Okay, it's a general aspect which is related to arts and science. Okay, of course, commerce too. I think you got the topic. It's called as intellectual property rights. Okay, let us discuss about few points on this. First, basics. I've got some exercise also for you, which you will try to understand them through them. Okay, and in the coming few sessions, we will discuss about this. I've got few materials for you regarding this. Students, what do you see here? There are two customers coming to the patent office probably and asking something. And see the manager being worried about it. Okay. All I asked was, can I patent my copyrighted trademark? Trademark is something which you have for a particular product or something, as a particular company, etc. Right? Somebody has copyrighted that. Okay? The person who's sitting here on the right hand side probably has copyrighted that. What is copyright? Copied that trademark. And he is asking the patent officer whether I can patent it. This is just an introduction to understand about what we need to learn in this chapter. Okay, what is trademark, what is copyright, etc. What is patent? Start thinking on these grounds. What are the various types of intellectual properties? Patents, trademarks, copyrights, unfair competition, and trade secrets. These all come under the intellectual property rights. Competition means someone has written a literature, somebody has written a poetry. Like how we go for plagiarism. Okay, like that. Copyrights is just a copy of some topic, some few things like that. Patents is something which somebody owns it. Of course, there are some frameworks for that. One need to understand about that. When he has to patent the product, what are each country has its small differences in the laws. Okay, what are trade secrets? All this we'll learn. Okay, to little more highlight you on this topic. Patents can be taken by application, okay, examination and grants. Trademarks and service marks, mainly trademarks, is by use in the interstate commerce, then registration. Copyright is something by writing something your own, perfected by declaration and registration. What are the different types of patents? One is utility. Secondly, it is a plant. Thirdly, it can be a design. Let's understand a little more on this. Utility is something whoever invents or discovers any new thing which is a useful process. It can be a machine, manufacturing machine, or a utilizable machine, or composition of a matter. Microbiology, when you talk composition of media, okay, new and useful improvements on some technology, they may obtain a patent, okay, subject to that particular condition and requirements of this title. Okay, this comes under the 35 USC and 101 sections. So something you invent, so it should be applicable, then only you will get the patent. Okay, you will only give the technology. You'll understand as I go a little more ahead with some examples. Plant patents. Whoever invents or discovers asexually reproduces any distinct and a new variety of a plant, it can be cultivated. Hybrids, it can be even the seeds, it can be the spores, it can be the mutants, like that. And newly found seedlings, okay, other than a tuber propagated plant or a plant found in an uncultivated state, okay. So it applies even for the plants only. No bacteria or similar single cell organisms need to apply for the patents in this category, okay. Design patents. Whoever invents any new original and ornamental design for an article of manufacture may obtain a patent, okay. This is also one can go for a patent. Let's say you made a new design of something, not only ornamental, anything, a new painting, a new article, all these will come under this. An invention is patentable, yeah, only when it is new, okay, when it is very useful, application oriented, not obvious, okay, pertains to patentable subject matter. Retain unless grant of patent is not barred. These are the conditions. It should be applicable, number one. It should be new. Then only a patent is given. Okay, and it should be maintained. No, patenting, when you do, it should be maintained by some fee. Okay, nearly around 17 years they give a patent, one product to be patented, right? Okay. There are a few exercises to understand about IPR. A human inventor looks forward for dash for his invention or her invention. There are options here. Just keep it in your mind. Anyway, for the time, I'll just give you some clues, okay? Economy, rewards, both A and B, none. Let's say somebody does a discovery. It's always like, why will they go for a patent? So I think you can guess the answer, right? It can be for some recognition, okay? And it will definitely give out an outcome. Once you have recognized, it will be applicable. Economy, okay? So I think you can choose the answer now. Great works like poetry, sculpture, inventions, any literature, scientific, it is known as dash. Physical, intellect, or it's just a property or intellectual property. So it's all an intellectual property, right? Because it's all intellectual related. Thinking, invention, innovative thoughts related, okay? IPR is an dash. Is it an idea? Is it an invention? Is it a design? Is the question. What is your answer? It is definitely some idea. Without idea, thoughts, you will not get it. It's going to become an invention and it's a design. I think you could choose the answer now. Right, students? Okay. So, IPR is something where somebody thinks, invents and designs. Okay. Yeah. IPR can be protected by trade design, patents and copyright, trade secret, plant breeders' right. Trade design, trade secret, patents and copyright, okay, plant breeders' right. So you would choose which option? Probably all the four are correct, right? Plant breeders also have some rights, okay? Let's say you've done a media formulation, or you developed a cell line for some vaccine production or something in an industry, or you've done some invention. Okay, what is it called? Trading, secrecy, both trading and secrecy, or it's called patent. Patent has its own meaning. It should be applicable. Okay. It should be something where it should be new. Okay. So it's purely something related to our industry here, what you're seeing. Industry related of its own. Media formulation is of its own. An industry inside work, what happens. Something which is own of their own, they will not try to give it out. Let us say somebody is producing alcohol, their own R&D lab is there in the industry, they made some media formulation and produce more alcohol. Would they like to go and give the technology outside? It's theirs already. They are making money out of it, right? Will they go for patenting? It's a media formulation. Okay, so I think you got the aspect. It is trading and secrecy. So what is disadvantages of trade secrets? Very economical, no protection, very legal, cannot be applied. Okay, you cannot apply it. It might be economical for the industry, but there's no protection. Some formulation is copied, someone can take it. Okay, how much legal is it? Cannot be applied means you have done a discovery, but you cannot apply it. It's only for your industry, you can make money. No patenting will come. Okay, as I told you, come back here. Identify what it is. It is for a limited duration. No. Is patenting for a limited duration? Yes, true. Should follow stringent rules for patenting? Yes. It is free of cost? No, not possible. Risk of someone utilizing the process is maximum. Somebody can use it. So, it's always a risk. Okay, you should not allow anybody to use it. Patent is a statutory privilege granted by the government. Okay, government only will grant it to an what? To an inventor or the industry for a fixed time, preventing using or selling the patent product. So government is protecting. So I've given you options here. I told you, wanted you to choose them. Patenting is something where government is helping you for what? To whom? To the inventor or the industry. How? Preventing from misusing that, using or selling. Okay? Yeah. I've got one more small exercise here. Tick the ones which can be paid.